Hello, and welcome to my channel. Today I'm going to be discussing how states can get involved and move the needle regarding blockchain adoption. Currently, there are talks about how Washington is moving forward with blockchain regulation, and I want to discuss some ways that the states can also get involved. First, I'm going to provide a brief background about where we're coming from. Second, I'm going to focus on how the states can implement specific ways to increase adoption and innovation. And all of this is going to include a high-level overview of some case law in order to explain the actions taken and why some of them were so disruptive to the innovation in the space. So let's just get right into it. A bit of background first is the Biden presidency was rife with a lot of actions of the then acting chair Gary Gensler. Chair Gensler was the head of the Exchange Commission, and he had consistently gone up in public and in front of Congress saying that there was one case to determine specifically security status for digital assets. He kept on citing a 1946 case called SEC versus W.J. Howie and Co. A high-level overview of that case would reveal that the defendant would sell orange groves in one contract and then offer the very same land purchasers an opportunity to lease back that land in a separate contract to a Howie in the Hills Servicing Incorporated. The Howie in the Hills Service Incorporation would cultivate, harvest, and market the citrus crop on the landowner's behalf. So the Supreme Court looked at the above case and how the transaction was sold and determined that it was sold pursuant to an investment contract and therefore should be regulated by the SEC. The main takeaway from this case is the test that was derived for determining whether something was sold pursuant to an investment contract. The test gave us four prongs. Some people argue three, but here's the four just to make it more clear. Firstly, it's an investment of money. Two, in a common enterprise. Three, with an expectation of profits. Four, to be derived from the efforts of others. Now, we're going to go into each of these prongs later in the channel, but first I just wanted to give a bit of a background on this case and why Gensler was constantly citing this when he was saying that specific assets, digital assets specifically, were sold pursuant to an investment contract and therefore securities sought to be regulated by the SEC. So um, essentially, that was what he was Gensler and the SEC was doing to determine whether these assets were sold pursuant to an investment contract. A prime example of what was clearly designated as security was a library token. So when the SEC was coming out around 2020, they were very, very interested in doing regulation by enforcement in that they would take companies to court instead of providing clear regulatory landscapes for people to build and develop their products. You could see a prime example of the regulation by enforcement was not necessarily shared by all acting commissioners at the time. Right now, and at that time, we had acting Commissioner Hester Peirce, who was outspoken against the SEC's actions in a specific case, and that we'll be discussing right now. That specific case was about a company called CoinSchedule, formerly known as Blotix. And what Blotix did was they provided information on over 2,500 digital asset offerings, specifically digital tokens. And one of those tokens was published by Blotix, was alleged by the SEC to be offered and sold pursuant to an investment contract, meaning that Blotix was required under Section 17B of the Securities Act to disclose compensation for profiling and publicizing said tokens. Consequently, Blotix settled with the SEC since it's well understood that saying how much you get, if at all, is important when you market an investment. These are reasonable regulations imposed by the SEC to ensure that people who are promoting information are open and honest and forthcoming with the investors in the market. However, one of the most explicit failures of the entirety of that action was that, and this is specifically mentioned by Hester Peirce, and I'm quoting now, is this failure to clarify was a symptom of a much larger issue, end quote. I specifically believe, and many others share, that the Gensler regime was unwilling to provide adequate guidance on how a token offering may be a security. Here, what happened was the offerings of up to 2,500 digital assets, the SEC didn't even say how many were offered. They specifically said that at least one was sold pursuant to an investment contract and shut that entire company down. The company wasn't a multi-million-dollar company. They didn't have the war chest to go to battle with the SEC, and they merely settled. And then the SEC got a judgment against them, and then that provided case law for them to continue regulating by enforcement. This was a blatant disregard for how we should promote innovation for an industry that is so promising as blockchain is. And we did see some dissent from Hester Peirce, but unfortunately, as the head commissioner, Gary Gensler, he was the driving factor in this type of regulation. So a lot of that action by former Chair Gensler had moved money and innovation offshore, ultimately harming the US consumer by limiting their participation in token projects and reducing the United States government from properly regulating a pivotal industry. This is where the states can come into play. Importantly, we see that Washington is intent on creating fair regulations that allow individuals and builders to create their products and access the US markets. But we don't need to wait for Washington to create regulatory clarity. The states have the opportunity to do it, and this is how I'm going to show you. The states should respond to this lack of regulatory clarity by using their own anti-deception capabilities alongside federal regulators and create their own regulatory regimes for digital assets. For example, a state could do many things. Firstly, the state could begin by defining digital assets. So it's important to be able to separate different tokens based on their character and use case. So payment tokens are going to be characterized, an example is going to be Bitcoin. That's something that the CFTC has come out and said that's regulated as a commodity. A utility token is very much like you're using an asset for a specific service. We'll get into that a little later, and how a utility token is different from a payment token, and how a security token is also different from a utility and a payment token. Just providing this clarity for digital assets is going to allow builders to move forward without having to wait for Washington and Congress to come up with comprehensive legislation. So the states are also going to allow builders in the space to register their token offerings under state blue sky laws. And a way that this would work is going to give the states enforcement powers, and they're also going to work with the federal authorities. So the way this is work is a state is going to say that any issuer offering to sell a digital asset to state residents shall file a notice of a token offering with the relevant division of the state, and they're going to include in that notice of a token offering the issuer identity, the token classification, the intended use, and the jurisdiction of distribution. So one of the most important things that people are looking for when they evaluate a token is obviously going to be considered the tokenomics, the distribution rate, the inflation rate, whether it's deflationary, how that token allocation is going to look. So the states providing for a registration of a token offering is going to provide real quantifiable and concrete data that that token offerers are putting out, that people can then use to determine whether they should invest their money in either payment tokens, utility tokens like Filecoin, payment tokens like Bitcoin, or security tokens such as LBC. Furthermore, states could also license digital assets. So money transmitters and mortgage lenders are interested in obtaining a license to be able to send, custody, and transmit these digital assets. They're going to need a state license for that. So one of the things that the state licenses would provide is on behalf of the customer is to ensure that the entity is properly capitalized, is to have those money transmitters or mortgage lenders have a minimum capital requirement, specific cybersecurity controls like we've seen in a bug bounty program where companies are hiring developers maybe through GitHub or other resources to vet their code, and using a lot of independent contractors to make sure that their product is safe and secure. Licensees for these money transmitters and mortgage lenders could be, if they're very, very new and they may not have the capital requirements to meet these standards, they might be able to get a more restricted license pursuant to an exemption for a new innovation, and maybe able to get 24 months to meet the threshold for FIT. This is going to be a really big jumping point, because a lot of companies, when they first start out, they don't have the capital for lawyers, for bankers, And maybe just getting the product running will allow them to raise capital and then deal with a lot of the regulatory clarity and license requirements thereon after. And then fourth, and this is really one of the most important things for potential investors that they want to see, is mandatory disclosures that highlight the token functionality, the risk, the tokenomics. So it's very common when people invest in these digital assets, they see something like fully diluted value, circulating supply, and the inflation rate, how the validators get paid out, whether even if the asset is deflationary, what does that even mean? So these are all things that are going to be just standardized disclosures under what we would call a Uniform Token Regulation Act, which is subject to each individual state's statutory structure. Any one state is not limited by another state. Obviously, conformity would be beneficial. But really, one of the things in these mandatory disclosures that I think should be pronounced is that these disclosures are going to be publicly available information, allowing individuals to make informed investments, not contributions. We want people to be making intelligent investments and allocations with their money. An example of what these disclosures would include would be technical functionality and intended use of the token, highlighting the token supply, the distribution schedule, focusing on the monetary policy of the actual token. It would also, these disclosures would highlight the governance model and validator concentration. You would want to know how decentralized the validator set is, whether it's a rotating validator set, how the validators are chosen. And you would also want to know whether there are cybersecurity audits, whether there are bug bounty programs to ensure that the entity you're investing with is up to par, so to speak. And really, you would also want risk disclosures, similar to risk disclosures that are made in 10K or annual reports for securities companies. You would want to know whether there is a material risk to an issuer for a myriad of reasons, such as there being only one individual who really pushes the company forward. You would want to know if that's the case because that might really deter an investment of a sizable amount to a more reasonable amount because of that heightened risk on that one individual. We would want to also include smart contract audits and making sure that they're reasonably understood by individuals. A lot of people who are reading on GitHub and these technical websites, understanding what audits look like, they're not going to be able to get real takeaways that are actionable. That's something that state disclosure requirements would be able to afford investors and thereby increasing the financial security of investors and making sure that these products can gain access to funds inside the US. Um, and then really importantly, you would want these disclosures to be updated quarterly, made publicly available on a website that is verifiable and secure, similar to SEC websites like Edgar. And really, at the end of the day, we all know that federal securities laws is stronger and cannot be contradicted by state laws. But states do have the ability to enforce anti-fraud provisions without overstepping federal authority. An example of that would look like a state coming out with a statute saying it's unlawful for any person in connection with the offer, sale, or exchange of a digital asset to employ any device, scheme, or artifice to defraud, making any untrue statement of material fact or omit a material fact necessary to make statements not misleading, to make them clear for people to engage in any act, practice, or course of business that operates as a fraud or deceit upon any person, and allowing the Attorney General or a state security division to bring a civil or criminal action for violations. So one of the reasons why these anti-fraud provisions would be so important is because sometimes a lot of these cases require an extreme capital cost for lawyers and attorneys fees. One of the things that really prevents people from uh, getting their claims heard is the fact that companies will be able to tie people up in courtrooms for many months, maybe even years, before they can get any redressability for their claims. And companies know this, that their size is intimidating to small investors. Someone who invests $25,000 or less is not really going to be able to reasonably hire an attorney and pay those upfront fees to go after their claim. And one way around that would be class action lawsuits, but there's a and we could go into this later, a myriad of issues where the issues among all investors has to be commonality. You have to find that all the injuries are of the same type and they affect everyone equally. It's very difficult to get a class action suit to move forward. And one of the things that is benefiting from this in the anti-fraud enforcement provision would allow the Attorney General to take on these claims by myriad of investors who might be in different situations and unable or unwilling to pay those lawyer fees and ensure that investors are taken care of without being prejudiced by the fact that they don't have the same income or capital war chest that would be common for a larger entity that's raising millions or tens of millions of dollars. This is something that I think the states shouldn't be reluctant to administer. I think that anti-fraud provisions, along with all of the other example statutes, would make states a laboratory for a lot of this innovation and bring a lot more money onshore, increasing security, increasing the chance of a lot of investors getting access to good investment opportunities, some things that are normally restricted to individuals with a higher income. Um, so just as like a high level overview before we go, and this is going to be the first of many videos, is we're just going to go over a little bit of what we said. So essentially, what these state statutes are going to be able to do is provide pre-sale disclosures for utility token offerings. We're going to provide a proof of secure code audit, allow people to make sure that the entities they're investing in, the audits that they're performing are readily interpreted by even the layman. We're going to have cybersecurity protocols for token platforms, ensure that these token platforms are using security companies that are functional. They're compliant with minimum thresholds for fit, that these companies are regulated and ensure that there's no piece of the chain that is that is integral and is flawed. So we need to make sure that every part of the cybersecurity audit is touched upon by a real regulated entity to ensure that there's no individual break. And really importantly, we need ongoing financial disclosures that talk about inflation rate, token allocations, what the vesting schedule is for early investors. We don't want people being subject to pump and dump schemes. We don't want investors who have token lockups to be able to only have those lockups for 3 months, where all of the hype is moving in, all of the liquidity is being pumped up, and then it's retail investors that aren't getting enough real actionable information to know when these big holders who got in pre-sale are able to unlock and where their rights vest. These are all really important disclosures, and I think that the states really have the opportunity to make sure that the US stays at the forefront of innovation in the digital asset space. Thank you very much, and I look forward for you to join me on my next video.